Good afternoon, everybody. Thanks for joining us for the second webinar in Conn Carey's 2019 OSHA webinar series. Today's program is an update about two really important OSHA rules, the rules that bring us as the employer community most in contact with and interfacing with OSHA, sharing our record-keeping data or picking up the phone to call OSHA to report injuries or fatalities to the agency directly. These are the electronic record-keeping rule and the significant injury reporting rule, two separate rules. The first faceless voice that you're hearing today is Eric Conn. I'm the chair of the OSHA practice here at Conn Carey, and my practice for the last now 20 years has focused essentially exclusively on workplace safety and health law, working with employers in inspections, investigations, and enforcement actions, primarily involving OSHA and the state OSH plans, but also the alphabet soup of other agencies that get involved in workplace safety and health issues. We handle also the full range of litigation, from criminal prosecutions to appeals of OSHA citations. I'm very pleased to be joined today by two of my superstar associates here at the firm who I truly believe are the foremost experts in the entire country on the subjects we're going to be talking about today. I'll brag on them so they don't have to brag on themselves, but Lindsay DiSalvo is, I think, the most knowledgeable person about OSHA's Injury and Illness Record-Keeping Program and expert in the analysis of whether injuries are reportable to OSHA under the significant reporting rule. And Deacon, another associate at our firm, knows more about OSHA's electronic record-keeping rule, both the data submission and the anti-retaliation elements, I believe, than anybody in the country, including the people that wrote the rule. So I'll let them introduce themselves a little bit, and then thankfully for you all, I'm going to fade into the background and let these two record-keeping gurus lead the discussion today, and I'll chime in from time to time if I feel like I have something interesting to contribute.
Good afternoon, everyone. This is Deacon speaking, and I'm going to be talking about OSHA's E-Recordkeeping rule. Just a quick background about myself. This is my fourth year at Conn Carey, and I work in both the OSHA and labor and employment groups, representing employers during inspections and investigations conducted by federal and state OSHA. And I also represent and advise employers in all aspects of the employer-employee relationship, reviewing handbooks, workplace policies, and procedures, and the like. So we have quite a big agenda and a number of topics to handle and cover here in today's webinar. And this is just a high-level overview of what we're going to be going over. So first, we're going to be discussing the data submission elements of the E-Recordkeeping rule and the anti-retaliation elements. We're going to get into the future of the E-Recordkeeping rule and some of the litigation, the ongoing litigation that is going on surrounding that rule right now. And then we're going to switch it over to Lindsay, who's going to be covering the significant injury reporting rule and what you can expect after reporting an injury. So like I said, I'm going to get started here on the electronic injury and illness data submission elements of OSHA's E-Recordkeeping rule. So from a high-level overview, there were two key elements to the rule, right? First, the data submission requirements, and second, the anti-retaliation elements. And this final rule was published on May 12, 2016. And as it relates to the data submission requirements, there were two major provisions. First, establishments with 250 or more workers were required to annually submit their OSHA 300 logs, 301 incident reports, and 300A annual summaries. Second, establishments with 20 or more workers in high-hazard industries, which was defined and outlined in the preamble itself and the standard, the list of high-hazard industries, they were required to annually submit their 300A annual summaries only. So the original intent of the data submission requirements, those have changed slightly, but the original intent under the Obama administration was employers were going to be submitting this data through a secure website, which we now know as OSHA's injury tracking application. And OSHA was originally going to be scrubbing employee identifying info and publishing that data on a publicly accessible database in a website. So the public could go on that database, search for a particular establishment or an employer, but as we know it, that's no longer the case, and we're going to cover that in more detail in a couple slides here. And finally, it was going to be used for targeted enforcement purposes. And as many of you know, OSHA recently rolled out its SST 16 Programmed Inspection Plan, so it has followed through on the targeted enforcement initiatives that were part of the original intent of the rule. So what was the electronic injury data submission requirement going to do? Well, first it was going to be quadrupling the number of employers that submit injury data to DOL on an annual basis. As far as establishments with 250 or more employees goes, we're going to see an increase from 38,000 submissions to 129,000 sites. And establishments with 20 or more employees in high hazard industries, that was going to go from 160,000 to 440,000 sites. After the first year of the data submission requirement, so for 2016 308 data, OSHA only received 215,000 submittals. So that was actually about 355,000 fewer submissions than what the preamble had projected. And some of the reasons for that less than expected submission was a number of things. First, a less than smooth rollout of the injury tracking application. There were a number of issues, including a potential security breach that was identified by the Department of Homeland Security, and the ITA was actually taken down for a couple of weeks until they could work out the kinks. And remember, there was the original concern about employee privacy and the privacy concerns about submitting data on this website. Second, there was confusion about the status of the rule because of delays and promises of change. And that was the transition between the Obama administration and the Trump administration. Employers really didn't know what to expect coming into the Trump administration and the new deregulatory agenda. And finally, not all state OSH plans had adopted the rule. And still to this day, there's three state plan states that have not adopted this rule, but a number of establishments throughout the country, including one very large state, California, had not adopted the rule under during the first year. So those were some of the reasons for the less than expected submission. However, here on this slide we have some statistics about data submission over the past two submission requirements, 2016 and 2017. So in the red, you can see during 2016, 76,000 establishments were submitting 308 data. For establishments covered by Fed OSHA jurisdiction, it was 139,000, roughly 139,000, combining for a total submission of 215,000. Transitioning 1 year later, we see that the total submissions was about roughly 260,000, and we see an increase in both the state plan states. Obviously, over the past year, a number of state plans have adopted the rule in comparison to when they hadn't in 2016. But the one thing that is interesting here is the box that is the beigeish color. And you see in 2016 there were about 52,000 submissions that were classified as out-of-scope submissions. And then in 2017 we have approximately 61,000. And those out-of-scope submissions are basically establishments that aren't covered by the rule but nonetheless submitted data. So that's a large number of establishments submitting data who simply aren't required to. And what we forecast is there's a number of reasons why this happened. As many of you know, in April of 2018, Fed OSHA did submit a press release requiring a number of different states that hadn't adopted the rule, basically telling establishments in those states that they were required to submit the data. So that's one reason why we think possibly there was an increase in the out-of-scope submissions, but also perhaps just general confusion around the rule itself.
Yeah, so that means there's a lot of employers out there who are voluntarily turning their data over to OSHA when they're not required to. And the one thing I don't think we've talked about yet, but we're about to, is, what is OSHA doing with this data? The number one thing they're doing with it is targeting enforcement resources. So, my general advice would be, I would not make courtesy submissions to OSHA. If you're not required, if you have establishments that don't meet the right number of employees, or you're in a state that hasn't adopted the rule yet, our general advice is don't submit until you're legally, regulatorily required to, because you do this courtesy for OSHA. The courtesy they may return is an inspection of your workplace. So we were very surprised to see such a large number of employers who are not covered by the rule submitting data. And if folks are doing that knowingly, I'd love to chat with you about what the motivation is, or what the strategy is behind that, and share my thoughts about that, because our advice would be to not share until you're required to do so.
Great. So what we've seen since the Trump administration has taken office is a change in course, and this rule has had lots of twists and turns since it was promulgated in May 2016. And I think it's fair to say, some things have changed, some things have stayed the same. So first, getting into some of those changes, though, there were employer concerns about privacy, and that's what purportedly motivated the change to not collect 300 and 301 data. Second, the Trump administration rejected the plan to publish employer data on the publicly accessible website, and they're refusing to share data pursuant to FOIA, at least temporarily. And that brings us to the final slide on the screen here, and that's related to the current lawsuit that has been brought by Public Citizen. They're claiming that OSHA illegally withheld injury and illness records. So Public Citizen had requested records, I think it was back in October, November, and December of 2017, and OSHA rejected their FOIA request, citing that one of the FOIA exceptions for law enforcement purposes. And since then, during the litigation, that justification has changed to the FOIA exemption for confidential business information. So that's a little more permanent. The law enforcement purposes FOIA exemption was going to be a little tough to justify withholding that information indefinitely. So this case is ongoing, and we'll mention it towards the end of the slides here when we're talking about the future of the rule. But this is something employers really need to keep an eye on, because the outcome of this case will be determinative of whether an establishment's injury and illness data can be accessed by the general public. So that brings us to the notice of proposed rulemaking that was brought over this summer, and the final rule that was just adopted less than a month ago on January 29th, 2019. So the original notice of proposed rulemaking, it had two proposed changes. First, to eliminate the requirement for large establishments, so those with 250 or more employees, to annually submit 300 logs and 301 incident reports. Two, it proposed to require establishments to submit their employer identification number along with the 300A data. So that new rule, it was issued, as I said, January 29, 2019, and it adopted both of these proposals. What the final rule did not do was address any of the anti-retaliation elements. So nothing about drug testing, safety incentive programs, or executive compensation. One update that we do have for you, if you're submitting this upcoming March 2nd, 2019, that's the third submission deadline. The ITA, the Injury Tracking Application web portal, is not currently set up to accept employer identification numbers, so you don't have to worry about that. Minor change to the rule this upcoming data submission. So, I mean, really, what has changed with this notice of, or with this final rule? I mean, not really a whole lot, because during, I think it was the fall 2017 regulatory agenda, President Trump and DOL had basically already indicated that they weren't going to be requiring employers to submit 300 logs and 301 incident reports. And during the second data submission process, there was a notice posted on OSHA's website instructing employers that they didn't have, large establishments, I should say, that they weren't required to submit their 300 and 301 incident reports anyway. So really, this is kind of formalizing what has already been in place. So this slide, quickly, I just want to go over the history of the key data submission deadlines. In 2000, for record keeping forms for 2016, that initial deadline, it was changing, and it changed several times throughout the course of the year, but it was ultimately December 31st, 2017. During that first data submission, all establishments, regardless of size, were only required to submit 300A data. 2017, as I mentioned, there was the notice, the announcement posted on the website and the injury tracking application informing large establishments that they weren't required to submit their 300 and 301 data. And that deadline was this past summer, July 1st, 2018. So now, for purposes of your 2018 300A data, that data submission deadline is now March 2nd, 2019, and it will be March 2nd each year hereafter, from now on. So this slide, we're going to go over quickly the enforcement policy as it relates to the data submission. OSHA's national office issued an enforcement memorandum on February 21st, 2018 to address the larger than expected set of non-responders. As I went over a couple slides ago, it was approximately 355,000 less than what they had expected in the preamble. So this certainly raised red flags to OSHA, and they needed to do something about it. So they instructed all their co-shows to evaluate whether establishments should have but did not submit injury and illness data, and that was during any inspection that they were performing. So if an employer failed to submit data but immediately provided their 300A data during that inspection, OSHA would only issue an other than serious citation with no penalty. Likewise, if an employer failed to submit but they had already submitted for the next calendar year, so for example, if you didn't submit your 2016 300A data, but you submitted the 2017 300A data by that July 1st, 2018 deadline, an other than serious citation would be issued with no penalty. However, if an employer couldn't or can't produce data, a citation will be issued with an appropriate penalty. And as far as looking at enforcement from the past year, calendar year 2018, there was 122 other than serious violations for small employers and 17 other than serious violations for large employers.
And you know, the one thing to think about in the context of enforcement here for e-record keeping is, I mean, if you look at these 139 citations, my guess is the average, actually not a guess, we did look at it, I think the average penalty across those was about $250, right? No big deal, except thinking about e-record keeping violations the same as record keeping violations. These are easy violations to have come up again as repeats, right? So generally speaking, you're not going to see serious record keeping violations because they're paperwork, but you can easily jump to repeat and willful violations now with maximum $130,000 plus penalties per violation. And they're going to be easy to find, easy to cite because you're submitting the data to OSHA or you're not. And once they, get you on the hook for a submission violation, it's easy to just look again to say, did this employer submit their data? And all of a sudden the repeats come flying in. So it's important to understand your obligations under this rule And if you happen to encounter one of these citations, even if it has a $250 penalty or a $0 penalty, to consider your options to see if you can't clear that off your enforcement record, because the repeat violations will be easy to pile up, especially if you're a location or an employer who has multiple locations around the country, and if you're one of those employers whose total number of employees at those establishments dances around the edge of being covered and not covered by this rule, it would be very easy to make a mistake and have repeat violations pile up against you. I see there's actually a bunch of really good questions about the data submission components of the rule. If you want to tackle some of those, that would be a good time to do it.
Yeah. So we have a couple questions here. One asking to clarify that we no longer need to submit 300 logs electronically. So you never were required to submit 300 logs electronically. Under the original rule, yes, you were, but the ITA hasn't been set up to accept submissions of 300 or 301 data, and now that that new rule, the final rule, has been finalized as of January 29th, 2019, removing that requirement, no, you are no longer required to submit 300 logs at all. Let's see, we'll tackle a couple more of these questions. Are these citations issued in the mail, or can they only be given if an inspection takes place? So OSHA is issuing mass mailers to employers who they think should have submitted data but did not. Typically, these citations are arising out of inspections. So they're not showing up just to check whether you submitted the data or not. But that brings up a good point also about the 6-month statute of limitations. So in this enforcement policy, this was in the context of reviewing 2016 data, and OSHA specifically said that the statute of limitations would run from, the 6-month statute of limitations would run from December 15th, 2017. I think it was, yeah, 2017. So that statute of limitations 6 months later, you're looking at June 15th, 2018. And the same going forward. So we have this past year, you were required to submit by July 1st, 2019. I think the math there is September.
January, right?
Oh, yeah.
6 months, January
6 months,
1st.
January 1st. And same thing going forward. March 2nd, 6 months later. I think that one will be, okay, June, July, August. So that's September 1st. So we're counting up here. September 2nd, 2019. So again, if you're not receiving some sort of inspection within those 6 months, likely you're probably running through the statute of limitations period to be cited for failure to submit the data.
I'll tell you what, though, that is a really great question about whether OSHA can just run a data set of employers they believe to be covered by the rule and just issue citations by mail. They've never done that before in any context, record keeping or otherwise. And generally speaking, their field operations manual calls for conducting an opening conference, performing an inspection, and issuing citations. So I would think that they would have to rewrite their field operations manual to start issuing citations without any other engagement, just saying, we see that data was not submitted, here's a citation. They would want to, I'm sure, do some independent assessment. Is the place of employment still open? Are the number of employees still triggering one of the threshold reporting requirements? So I'd be very surprised if they started doing just a quick data analysis of their website, of the ITA, and just blanket issuing citations. But a really interesting question. It'd be interesting to see what they end up doing from enforcement of this rule going forward.
All right, and that brings us also to the SST Inspection Program. So OSHA launched the SST 16 inspection plan this past fall in October 2018. And what that does is it basically outlines OSHA's strategy to target establishments for inspection based on their 300A data collected under the rule. So it specifically only applies to non-construction workplaces with 20 or more employees. And this is going to be based on calendar year 2016 300A data. And the inspection list is going to be, it includes establishments with DART rates above a certain undisclosed threshold. It hasn't really been established yet. And additionally, there's a random sample of establishments that OSHA believes should have but did not submit 2016 300A injury data included in that list, and also just a random sample of low injury rate establishments. So ultimately, all non-construction workplaces are subject to the SST Inspection Program. There are, however, I will tell you, the targeted establishments, those that do pop up on the list. So this is going to be a software-generated list by OSHA every couple months. And if a targeted establishment does appear on the list, it will be deleted if it's no longer in business or it's received a comprehensive safety or health inspection within the past 36 months. So they're within the last 36, or within the last 3 years. Also, if you're a VPP or SHARP participant, you're going to be removed from that list. And then finally, if you're a public sector employer. So I saw that we received a question about the state plans, and we're going to get to that right now. So not all state OSH plans have adopted the rule, and the remaining delinquent states that we have are listed here on the screen: Maryland, Washington, and Wyoming. So as many of you know, April 2018, Fed OSHA issued a press release instructing employers in states that had not yet adopted the rule to submit their 300A data for covered establishments. And there were a number of conflicting responses from state plans. However, none of them required establishments to submit data by the July 2018 submission deadline. And the reason being is OSHA cannot lawfully direct state employers to act. The remedy there is to rescind the state plan's approval, as basically rescind their state plan status. They can't direct or govern employers in those states to take action. So we'll talk specifically here about California because that's one of the states that has most recently adopted the rule, and that was, again, this past fall, October 2018. They published an emergency proposed rule to temporarily implement the E-Recordkeeping rule, Fed OSHA's E-Recordkeeping rule. It was approved by the California Office of Administrative Law, and it was effective November 1st, 2018. And the interesting part of this emergency rule was that it required retroactive submission of 2017 300A data. So employers were given basically less than 2 months to make sure that they submitted data by December 31st, 2018. The next data submission deadline, basically 2 months later, March 2nd, 2019. So California covered establishments have been busy. If they were submitting in December and again now in March. So final, to tie this up, the California rule, it was an emergency proposed rule, so they still need to go through finalizing this through the rulemaking process. So they need to go forward with a formal rulemaking, and they still need to permanently adopt OSHA's E-Recordkeeping rule. So now we're going to get into the anti-retaliation elements of the rule, which is the second key component of the rule. And just a little bit of background here. Where did these anti-retaliation provisions come from? Well, they appeared briefly in a supplemental notice of proposed rulemaking after receipt of comments during the initial rulemaking. So basically the supplemental notice of proposed rulemaking was responding to complaints that the rule would ultimately lead to underreporting and underrecording of injuries and illnesses. So these anti-retaliation provisions, those that you guys know well now, the provisions related to reasonable reporting procedures, post-incident drug testing, and safety incentive programs. Most of those didn't appear in a regulation itself. They appeared in the preamble. So if you're looking for guidance, and we'll talk a little bit about this now, there isn't that much guidance in the preamble about what is reasonable reporting, a reasonable reporting procedure, or how to implement post-incident drug testing, or what is a permissible safety incentive program. But first we'll start with these reporting policies on this slide. So as of December 1st, 2016, employers were required to 1, inform employees of their right to report workplace injuries, 2, inform employees of their right to report work-related injuries free from discrimination or retaliation, and 3, this is the important one, update internal injury reporting policies to remove unreasonable elements from their policies. So what was considered a reasonable reporting procedure? As I mentioned, it was vague and left mainly undefined in the preamble. So OSHA subsequently issued a guidance memo in October 2016 with some additional, albeit brief, guidance on what is a reasonable reporting procedure or policy. And what we glean from that and from the preamble is that OSHA can cite employers for implementing policies with a perceived retaliatory effect for reporting injuries. So notably, for example, those policies that discipline for late injury reporting. So it would be unreasonable to discipline workers for failing to report while they're incapacitated or before realizing an injury. So if we're talking about a latency period, you can't just have a policy that says report immediately. That would be considered unreasonable. Second, discipline for violating vague work rules. So those work rules such as work safely or maintain situational awareness, those are going to be highly suspect under the rule. What you can do, however, is you can require employees to report injuries as soon as practicable, and that's some of the magic language that you can use. As soon as practicable after realizing they have a reportable injury. So this is, again, to accommodate injuries with a latency period, for example, MSDs, musculoskeletal disorders. Finally, you can discipline for violating safety rules, legitimate workplace safety rules, if they're done consistently. So it's really important to maintain and clearly communicate your workplace safety policies to your employees. Ultimately, employees, or employers, I should say, they need to ensure discipline is dosed out consistently and imposed for legitimate reasons. Moving on to drug testing, the primary concern in the final rule was that drug testing can dissuade a reasonable employee from reporting a work-related injury because it's an invasion of privacy. So the key principle from this rule is that post-incident or post-injury drug testing cannot be used as a form of discipline. The one clear limitation that we have in the rule is that blanket post-injury drug testing policies are strictly prohibited. So if you have a policy like that, where if you're drug testing employees automatically simply because there was an injury, that is going to be problematic, and OSHA will take note of that. However, there are a number of drug tests that were not impacted by this rule. Again, just post-incident drug testing. So the following that you see on the bottom half of the screen, those are still permissible. Pre-employment screening, random drug testing, of course, this is all subject to state law limitations as well, to comply with state or federal law requirements. For example, mandatory post-accident tests required under DOT regulations, and also if it's required by a workers' comp insurer, for example, for premium reduction policies. So the primary thing that you should take away from this post-incident drug testing discussion is that it can be used as a tool to evaluate the root cause of a workplace injury. So a post-accident drug testing is permissible if you have a reasonable basis to believe drugs or alcohol contributed to that incident. The rule is only prohibiting drug testing employees for reporting work-related injuries without an objectively reasonable basis for doing so. So OSHA provided that in the guidance that requiring a post-accident drug test, for example, for a forklift operator who's injured in a forklift crash, especially if there's evidence of reckless operation of the truck, would be permissible. Conversely, if you have an employee that suffered a bee sting, that's something, if you're conducting a post-incident drug test after that, that's likely going to be considered unreasonable and violative of this rule.
And another big category would be sort of those musculoskeletal disorders, an ergonomic injury from, a repetitive strain, repetitive stress activity is not likely to be drug or alcohol related, so it would be harder to demonstrate a reasonable basis for testing in those circumstances.
And I see a question here about what about reasonable suspicion. So OSHA signaled that there doesn't need to necessarily be reasonable suspicion that alcohol or drug use was used or caused a specific incident, just that drugs or alcohol are a reasonable cause for the type of incident. So it's a little bit different inquiry. Moving on to the safety incentive programs and those provisions of the rule. So OSHA's primary concern was the chilling or retaliatory effect of safety incentive programs. So as you see on the screen here, we have some thumbs up and thumbs down, and based on the preamble in the October 2016 guidance, this is the type of examples that were generated as permissible and not permissible. So bonuses for employees or crew.
Or I wouldn't say not permissible. The thumbs down is one that would receive scrutiny to see if there is, retaliatory impact, chilling impact. So it's not a clean up or down. It's a one is likely to be reasonable and one is potentially unreasonable and subject to scrutiny.
And OSHA's position on this has changed slightly since the rule was promulgated itself, but right, as Eric was mentioning, those that would receive scrutiny are those with the thumbs down. So bonuses for employees or crew for having no injuries over a certain period of time, or rewards, a reward or denial of a benefit or bonus based on injury rates. And then finally, frontline supervisors, bonuses tied to injury rates. Some that were considered outside the scope of what would be suspect are those that are based on more leading indicators. So, for example, raffles and a raffle in the month that all employees comply with legitimate safety rules, such as using their hard hats or using their fall protection, or a bonus for employees observed working safely, reporting on safe conditions, completing training, or participating in a safety committee. Those are the types of programs that OSHA views more favorably.
And then one last point here. These last two bullets are often seen as inconsistent and confusing to people when we talk about this. The concept here is that OSHA believes, and this is historical and going back through guidance associated with the VPP memo and some congressional guidance, that you would frontline supervisors, OSHA believes, have a greater ability to control the environment about reporting injuries. And the frontline supervisor, if his bonus is tied to an injury rate, foreman, frontline supervisor, location manager, they're more likely to be able to demonstrate to the employees that they don't want injuries to be reported and more easily chill the reporting of injuries. But a senior manager or executive level manager is less likely to be able to influence employees, rank and file employees' willingness to report injuries because they're so far removed from that direct interaction from employees. So that's why there is a different view for senior manager versus frontline manager.
Mm-hmm. And I see we have a question come in here about frontline supervisors. So frontline supervisors can't have a metric in their review regarding safety. So I'm just going to skip the enforcement slide here really quick, and we'll come back to it. But we'll talk quickly about the update to the Fairfax and VPP memos. So August 2017, OSHA issued its revised VPP Policy number 5 memo, and that updated its position on safety incentives and executive compensation or bonus policies. So the original VPP policy memo, if you guys remember this, it was basically a pretty rigid table about what type of program it was, what type of indicators were being used, lagging versus leading indicators, and whether that was viewed as permissible or suspect based on the category of employer. So if you're a frontline supervisor and their bonus was based on meeting a certain injury and illness rate, that was going to be more suspect, and that was spelled out within the table. If you were a CEO and part of your bonus was tied to that, that was generally considered outside the scope, and OSHA wasn't really concerned with that. What the revision did, though, is basically it states, that was out the window. It's completely archived. And what it does now, it's very brief. It identifies two types of programs that OSHA should look for. One, in programs that reward workers for reporting near miss and hazards or encourage participation in overall safety. And two, they should be looking out for rate-based programs focused on numbers or rates of injuries. So these are not prohibited, programs that are based on rate-based factors are not prohibited under this revised VPP policy memo. What you need to do is show that, however, show that there's precautions to ensure the policy does not discourage reporting. What those precautions are, we really didn't get a lot of guidance on that in the memo itself. However, things like training in mandatory reporting, discipline for non-reporting, attendance at safety meetings and trainings, again, there's leading indicators. Also, you can cross-check your workers' comp claims against recordable injuries, and then identify any red flags that require further investigation, just ultimately showing that you're taking steps to encourage reporting and not have that chilling effect. So quick, we'll go back to the interim enforcement memo that was issued in November 2016, and this memo explains to COSHAs how to investigate and determine the merits of a retaliation claim. So the area office, when it gets a retaliation complaint, it's going to refer that complaint to OSHA's whistleblower protection program. So an informal conference that you're having concerning any one of the anti-retaliation elements might include the area office and the whistleblower protection program folks, and they're often going to be in consult with the regional solicitor. Some of the potential remedies that you may face if you're found to have violated one of these is back pay, even reinstatement, and ultimately the goal is to make the employees whole. So in October 2018, OSHA issued guidance on its anti-retaliation elements. And this was during the rulemaking of the amended rule that was just finalized this January 2019. Again, the anti-retaliation elements weren't part of this most recent change to the rule, but they did receive a lot of comments about the anti-retaliation elements during the comment period for this rule. So what they did is they issued this memo, and it clarified their position that the E-Recordkeeping rule does not prohibit all safety discipline, safety incentives, or post-incident drug testing. What it really did was reinforce the idea that employers need to enforce legitimate safety rules. It did, however, provide some more clarity on what precautions employers can take to address potential underreporting where injury and illness rates are used as part of a safety incentive program. And we went over some of those on the last slide. Incentives for IDing unsafe conditions, training programs for all employees to reinforce reporting rights and responsibilities, and emphasizing non-retaliation policies, and finally implementing mechanisms for accurately evaluating employees' willingness to report. So quick, we'll go over some enforcement of the anti-retaliation elements. From December 2016 to the present, OSHA has only issued 11 citations under the anti-retaliation elements of the rule. This isn't that many. As you can see, 7 other than serious citations for alleged violations of 1904-35B1(4), and that's for adverse employment actions against an employee who reported a work-related injury or illness, and only 4 other than serious citations for alleged violations of 35A1 and 35B1 for maintaining unreasonable procedures for reporting work-related injuries and failing to inform employees about their reporting rights.
You know, the one thing I would say about this is, you know, the biggest objection that industry has had to the anti-retaliation elements of the rule, of this e-record keeping rule, is that everything that is purportedly now unlawful under the e-record keeping rule has been unlawful under the OSH Act since the OSH Act was promulgated. Section 11C prohibits discrimination or retaliation for taking adverse employment action related to a protected safety act, and reporting an injury has always been considered a protected act. So the fact that there's been 11 citations, it may not be, and I don't think is actually reflective of the amount of anti-retaliation enforcement that's gone on in this area, because OSHA is continuing more or less business as usual in accepting complaints under Section 11C, investigating complaints under Section 11C, and bringing actions under 11C. To me, this is all a supplement and duplicative of 11C, which is why we have, submitted comments on behalf of industry groups calling for the repeal of the anti-retaliation elements, because they're purely duplicative from our perspective.
Thanks. And I'm seeing a lot of questions come in about primarily what is an establishment and that analysis. So I quickly want to go over that really quick. So this is a location-specific analysis, and it's not, employer-wide. So when we're talking about the employee count for an establishment, you're talking about one specific location. You're looking at the total number of employees at the peak employment during the year. That's going to be including temporary workers, seasonal workers, and any part-time employees. So it's one single physical location. So that the 250 or more requirement under the rule, that's not employer-wide. That's one specific establishment, one location. And the same goes for the 20 or more in a high-hazard industry. And that high-hazard industry list, I see a couple questions about that. That's going to be based on your NAICS code. And if your NAICS code falls within the high-hazard industry list that OSHA specifically provides in the rule, then you fall under that category. And if you have 20 to 249 employees, you're going to be required to submit your 300-day data.
There was another question I saw, that if your NAICS code is in the just general partial exemption list under the record-keeping standard, in other words, you're not even required to maintain a 300 log because you're in a very, very low hazard industry like some retail and office settings. Are you required to submit electronic data if you have, say, 300 employees at a very low hazard industry location? And the answer is the e-record keeping rule only applies to those employers who are covered by the record keeping rule. So if the record keeping rule does not require you to keep logs, then you don't have to submit data under the e-record keeping portion of the record keeping rule.
Great. And we got to get to the serious injury reporting part of the presentation, so I'm just going to tie everything up here with the future of OSHA's E-Record-Keeping Rule. And these next two slides, really I'm just going to talk about the four current lawsuits that are going on surrounding this rule. I mean, we really don't know going forward what will become of the rule. We see that the new administration really hasn't taken that much action on this rule. After the new administration rolled in, there was a lot of industry backlash and hope that this rule would be significantly revised or even repealed. However, we haven't seen that, and it doesn't look like this will be resolved or modified in any future rulemaking either. But what we do have is four current lawsuits that you really need to keep an eye out on. Two, one related to the anti-retaliation elements and one related to the data submission requirement. And those are in the Northern District of Texas and the Western District of Oklahoma. Both cases were indefinitely stayed pending the reconsideration of the rulemaking. But since that rule just came out, about 3 weeks ago, it's likely that both of these cases are going to go back on the active docket in the near future, and we're going to have to wait and see what becomes of those. Finally, the other two that you really need to keep an eye out on, one we already discussed, that's the challenge to the FOIA withholding. OSHA was sued for withholding the injury data under the FOIA exemption for active law enforcement investigations. Again, that justification has changed now to the exemption for commercial or financial information, and that's intended to be a more permanent fix. And finally, one of the most recent ones, this was just filed about 3 weeks ago, and that's a challenge to the rollback of the data submission requirement, the new rule that just came out in January. Public Citizen actually filed the complaint the day after the rule was rolled out. So the main arguments there you can see on the screen. It's arbitrary, capricious, and abuse of discretion. And they basically are saying OSHA didn't provide a reasoned explanation for the change or consider any of those opposition comments. And with that, if you guys have any specific questions about the E-Record-Keeping Rule, the upcoming data submission deadline, feel free to reach out to us. Our contact information is going to be on the last screen. I know that we had a lot of questions that we didn't get to. If you have a specific question, again, please feel free to reach out, and we'll be glad to answer that for you. So I'll turn this over to Lindsay now, who's going to be discussing the significant injury reporting rule.
All right, good afternoon, everyone. As Dan said, my name is Lindsay DiSalvo, and I'm an associate here at Conn Carey. And I'm going to try to move through these slides somewhat quickly, just so we can get through everything. But to the extent that there are additional questions and that there are questions on the material that I'm going to go through now, we will try to save some time to answer a few of those questions at the end of this portion of the presentation. So I'm going to go through now the significant or serious injury reporting rule and some of the nuances that go along with this rule. So this first slide just kind of shows the development of this rule over decades of time since it was first implemented. So back in the 1970s, the rule was originally implemented. And as you can see, the rule in 1971 and 1994 really just centered on hospitalizations and fatalities. And those two rules were more focused on catastrophes. Back in 1971, it was a fatality or 5 or more hospitalizations, 5 or more employees hospitalized. And then in 1994, it was a fatality and then 3 or more employees who were hospitalized. Those were the only two instances where an employer was going to have to go ahead and call OSHA and report the incident. But in 2015, this changed significantly. It's still fatalities that have to be reported, but now it's just 1 or more employees that are hospitalized, and specifically inpatient hospitalization, which we'll get into in just a couple slides. And now the rule also requires that employers report amputations as well as loss of an eye. And then the timing for the report has changed over the decades. So you see in 1971 it's 48 hours. Now a fatality has to be reported within 8 hours of when the employer learns of the fatality, or for hospitalizations, amputations, and losses of an eye, it's within 24 hours of when the employer learns of the fatality. So this slide is just sort of a little bit of background on the significant injury reporting rule. It was promulgated back in 2014, but became effective on January 1st, 2015. So as of January 1st, 2015, these specific outcomes that I discussed on the last slide do have to be reported to OSHA if they meet the requirements set out in the standard. Similarly to what Dan was discussing with the E-Recordkeeping rule, state plans were also expected to adopt a rule that was just as effective as the one that was adopted by OSHA. So some state plans actually already had rules that had more stringent requirements, faster reporting times, a broader range of outcomes, employee injuries that had to be reported to OSHA. So some states didn't actually have to make changes to their significant injury reporting rule, but those that didn't have provisions in their standards that were as effective as OSHA had to either adopt this same standard or they would have to have a standard that's even more stringent. OSHA expected that this change in the rule would result in a significant increase in the reports, and OSHA was actually predicting somewhere around 100,000 more significant injury reports. As you'll see from the data that we have, that is not the case. Reports did spike significantly, but not quite to that level. And then, the idea here, similar to the E-Recordkeeping standard, was that this would result in more reports to OSHA, which OSHA could then go out and inspect in certain circumstances and then cite as necessary after this inspection. OSHA guidance does provide that the minimum penalty for the failure to report is $5,000. There's discretion, I think, to go up to $7,000 to create a greater deterrent effect if OSHA deems that necessary. But a lot of these penalties for failure to report are going to be around $5,000. So the first specific issue we'll talk about related to the rule today is this concept of inpatient hospitalization, because this is a real source of confusion. OSHA does define inpatient hospitalization in the standard as formal admission to the inpatient service of a hospital or clinic for care or treatment. But there are two sort of main components there that an employer has to assess when evaluating whether something is actually reportable inpatient hospitalization. And that first component is whether they were admitted to the inpatient service. So that's number one. And then if the employee was actually admitted to the inpatient service, did they receive care or treatment while they were in the inpatient service? So reportable inpatient hospitalization has to meet both of those criteria. As you'll see in the next bullet, this doesn't include admission for just observation or testing. So if for some reason treatment occurred in the emergency room, which we actually see happen quite commonly, and then the employee is admitted to an inpatient unit just to be observed afterward, that's not going to be a reportable inpatient hospitalization because care or treatment hasn't occurred. An important note here, though, care or treatment in this context is going to be a little bit different than in the general record-keeping context. So injuries or illnesses have to be recorded if they result in medical treatment beyond first aid, but in this context, it's any level of care or treatment. So if an employee is admitted and then after admission only receives first aid, that's still going to be considered care or treatment, and that would still be a reportable inpatient hospitalization as long as the other elements of reportability are met. The standard no longer requires an overnight stay. Generally, if an employee is going to be admitted to the inpatient unit, it is likely going to result in an overnight stay. But if you do have the circumstance where an employee is admitted and they're just admitted for the day and they're let out, as long as they're admitted to the inpatient unit for care or treatment, that's still going to be a reportable inpatient hospitalization. And OSHA has recognized that there is some confusion about some of these terms, particularly what does admission mean, because admission can mean a different thing to the insurer versus the hospital versus the employer and the employer's understanding. So to address that, OSHA has said that the analysis should really focus on whether the employee was considered an inpatient versus an outpatient. And the outpatient is generally going to be if the employee is taken to the hospital and they receive surgery or are treated in the emergency room and then, released without being admitted to the inpatient service. So these are two examples that I think really show and clarify how the concept of inpatient hospitalization works, because there are some really significant limitations on what needs to be reported as an inpatient hospitalization. So the first one, the employee breaks their leg, goes to the emergency room where the leg is set, the employee is administered a prescription drug there to treat the pain, and then the employee is released. The employee went to the hospital, they were treated, it sounds like, for a very serious injury, a broken leg, but because they were treated in the emergency room and weren't admitted to the inpatient unit before they were released, that's not going to be a reportable hospitalization. And then the second one, an employee breaks their leg, goes to the ER where they begin to bleed out. The ER then replenishes blood before setting the leg, but then sends the patient from the ER to an inpatient ward where they're admitted for monitoring. This again, despite how the facts sound like this should be, a really serious hospitalization, and it is, because of the fact that the employee was treated in the ER, received all treatment in the ER, and was only admitted for purposes of monitoring, this still is not going to be a reportable inpatient hospitalization. So some really important, like I said, limits to what is considered an inpatient hospitalization based on the definition provided by OSHA. This chart here shows, again, that spike I talked about, which is the trend OSHA expected, but significantly less than what OSHA's expectation was. You'll see in 2014, before this new reporting rule was promulgated, back when it was 3 or more employees had to be hospitalized for it to be a reportable hospitalization incident, there were about 94 reports made to OSHA in 2014 under that prior standard. And then you see in 2015, when we bring in just a single employee who is admitted to an inpatient unit for care or treatment, you see that spike significantly, almost over 7,000 reports based on that new standard. And then going forward now to 2018, you'll see it's almost a continuous increase, a little bit of a drop between 2016 and 2017. But then you get to 2018, and all of a sudden we have a pretty big jump from 2017 to about 9,135 hospitalization reports made in 2018.
And that's just a Fed OSHA number, right?
That is just the Fed OSHA number, yep. Those statistics are from Fed OSHA. So aside from inpatient hospitalizations, another big area where reports are being made are amputations. And again, OSHA does define the term amputation in the standard. It's the traumatic loss of a limb or other external body part, and it has to be the entire limb that is amputated or part of a limb or appendage that's completely severed, cut off, or amputated. There isn't real clear guidance on what the whole concept of a partial amputation is, whether it is the complete severing of the part of an appendage, or whether it's, getting severed to a point where it's just sort of hanging on a little bit. OSHA has not specifically addressed that issue, but based on what we've read from the guidance that there is, our interpretation has been that it has to be a complete severing of a part of the appendage that would constitute a reportable partial amputation. The standard specifically says it does not include avulsions, enucleations, deglovings, and scalpings. It can be tricky sometimes to interpret what is considered an amputation versus an avulsion, and that conclusion is going to be very dependent on how the doctor classifies the injury. So OSHA's expectation, and they've clarified this in guidance, OSHA's expectation is that if a medical professional classifies something as an avulsion, then the employer should use that to determine whether they have a reportable incident or not. If the medical provider does classify it as an actual amputation, then the employer should proceed based on that classification. The standard also specifically includes fingertip amputations, and it says with or without bone loss in the standard. So our understanding of this is that OSHA really wants to be aware of those types of injuries, of any level of fingertip amputation, because they see this as probably a guarding issue or a lotto issue, a lockout-tagout issue. And those are big areas for OSHA and the types of things that they want to be aware of and potentially inspect. This is sort of tricky because you could have an amputation of a fingertip that doesn't even require medical treatment. That is something that is really just potentially addressed by like a Band-Aid. But OSHA has been really specific that it is with or without bone loss. So generally, if there's any level of the fingertip that is amputated from the top of the finger, we're likely going to recommend that that be reported.
But I would say that only applies to the fingertip. So you might have some other part of your body, like around your bicep or something like that, where you have an avulsion or a nucleation where a chunk of your skin and cells and membrane and that sort of stuff is injured and removed, but no bone loss. That is likely not to be considered an amputation. Now, you may be reportable for another reason if you end up hospitalized or something like that, but this amputation without bone loss only applies to the fingertip.
Right. And again, like I said, it is very dependent on what the medical professional does determine and how they classify it, and that will weigh heavily in the employer's determination of whether it is a reportable amputation. And then finally at the bottom, you'll see that amputation does also include medical amputation. So there can be an instance where an employee suffers an injury so severe that when they get to the hospital, the doctor makes a determination that the finger or toe has to be amputated. And so a medical amputation can be a reportable amputation if it meets the time limitations, which we'll talk about in just a couple of slides. So beyond just how the term amputation has been defined in the significant injury reporting standard, there are some other issues related to amputations that can impact whether the employer needs to report. There's actually a separate reporting requirement for specific types of amputations under the standard that regulates the use of power presses, which is 1910-217. This standard creates a separate duty for employers to report all point of operation injuries to operators of mechanical power presses, and that report needs to be made to OSHA within 30 days of the occurrence. So this is important because there may be instances where an injury like this does result in amputation, but it might not occur within the 24-hour time frame that the significant injury reporting rule requires. However, if it does lead to an amputation and the amputation was, the result of a point of operation injury, then it still might be reportable to OSHA under this standard within that 30-day window. Additionally, there is still an active amputations national emphasis program, and the current version of that NEP requires that certain employers meeting specific NAICS codes as defined in the NEP, if those employers report an amputation, OSHA is supposed to perform an on-site inspection of that particular employer if it meets the requirements as set out in the NEP. There are certain types of injuries that do not need to be reported. Specifically, the standard lays out the two at the top there. Fatality or injury that results from a motor vehicle accident on a public road, and then also a fatality or injury that occurs on public or commercial transit system. So pretty specific exceptions, pretty narrow, but they are important because there are a lot of employers who have people who might drive as a part of their duties, and even if they are driving as a part of their duties, if an accident that occurs on a public road leads to their injury, then that's going to be something that is exempted from the reporting standard. And then the latter two we've discussed a little bit already, inpatient hospitalizations for diagnostic testing or observation only, and then any outpatient care or care that occurs prior to the employee being formally admitted to the inpatient unit of a hospital or clinic. So aside from the outcome and whether that triggers reportability, there is also a requirement that the injury or illness be work-related. And work-related is a pretty broad definition. It is defined elsewhere in the record-keeping standard, and it is whether the injury or illness is caused, contributed to, or significantly aggravated by an event or exposure in the workplace. OSHA does establish a geographic presumption for work-relatedness. So if the injury or illness results from an event that occurs in the workplace or in the work environment, it is broader than just the office that the employee works in. It's anywhere that employees work or are present as a condition of their employment. If you know that an injury or illness resulted from something that occurred in the work environment, then OSHA presumes that it is recordable. It's recordable and reportable as work-related. So if it is unknown whether the event or exposure occurred in the work environment, then there is the more likely than not standard. And what that is the employer must assess whether it's more likely than not that an event or exposure in the work environment either caused or contributed to the injury. And in this context, it's important to remember that it has to be a cause or a contributing factor. The work environment doesn't need to be the only cause or the only contributing factor to an injury or illness. Additionally, in the context of the geographic presumption, there are some exceptions. One that we see a lot and I think can be really important in the reporting context is where an employee's signs or symptoms arise at work, but those signs or symptoms are related to a completely non-work-related condition. OSHA uses the example of epilepsy as something that might not be work-related. So an employee has an epileptic episode or a seizure in the workplace, and as a result falls and injures themselves. That injury is not going to be considered work-related because of the fact that it solely results from a condition that has nothing to do with the work environment, the employee's epilepsy. So that's a really important exception in this context. Not only, the epilepsy example, but we also see this come up sometimes with heart attacks. A heart attack occurs in the work environment, but a heart attack is often a sign or symptom of something that has nothing to do with the work environment and that was not caused or contributed to by the work environment. So that's a really sort of important exception to keep in mind in the work-related context. And then the final point here, there is no eggshell exception. So if an employee that works for you happens to have brittle bones, for example, and they trip and fall in the workplace and they break their ankle, resulting in an inpatient hospitalization, it doesn't matter that it's because of their brittle bones that they had a break where someone else might have just, bruised themselves or gotten a scratch or something like that. The employer has to take the employee as they are and determine whether to record or report based on that. So when does the time clock for reporting start? In the case of fatalities, an employer has to report within 8 hours of when they learn of the fatality. And here, when they learn of the fatality means not only when they learn of the employee death, but also when they learn whether the employee death was work-related. So they have to learn of the elements necessary to determine reportability, and that starts the 8-hour time clock. For amputations, inpatient hospitalizations, and losses of an eye, it's within 24 hours of when they learn of the serious injury. And again, that means not only learning of the injury itself and the circumstances that led to the injury, but learning that it was, in fact, a work-related injury before they are required to report. And then at the bottom, these outcomes are only reportable if they occur within a certain time period. And that's really important. That's straight from the standard as well. a fatality has to occur within 30 days of the incident for it to be reportable. It's a long period of time, but if something happens and the employee death doesn't occur until day 31 or 32, then it's not going to be a reportable fatality. In the case of a hospitalization, the inpatient hospitalization must occur within 24 hours of the incident, and then similarly for an amputation or loss of an eye, again, that needs to occur within 24 hours of the incident. So this kind of lays it out more specifically.
I would just add, the circumstance where we see that come up the most often is in the medical amputation. Are you about to talk about that? Go ahead.
No, so this slide shows sort of how that process breaks down a little bit further, and then we'll talk about some common timing issues that we've seen. So here, the time clock to report an inpatient hospitalization triggers from first, when the hospitalization actually occurred, second, whether the hospitalization resulted in the inpatient admission for medical care or treatment, and also whether a cause or contributing factor of the hospitalization is work-related. So these are the three components that the employer needs to learn before that time clock for reporting is triggered. And then for illnesses, and we haven't really talked about illnesses too much, and we don't really see this issue come up as much with illnesses, but it is important to note that in the case of an illness, the trigger for reporting an inpatient hospitalization is that the inpatient hospitalization must occur within 24 hours from the time of exposure. This slide shows three common timing issues that employers can face in the reporting context. This first one here, delay in formal admission to inpatient service, we've already discussed a little bit, but an important note here is that hospitals are incentivized to maintain patients in the emergency department by insurers because insurers do charge higher rates for emergency services. So this incentivizes them to maintain people in the emergency department as long as possible, which could result if treatment is occurring in the emergency department. This could result in employees being maintained in the emergency department longer than 24 hours from the incident, which would put them outside of the inpatient recordability or reportability issue. So in that case, if the employee is maintained in the emergency department and doesn't actually get admitted to the inpatient unit more than 24 hours from the incident, then this would not be a reportable hospitalization. The second one is medical amputation post-injury. So this is a scenario where you have an employee who may have suffered a really serious injury in the workplace, goes to the hospital, is seen by a medical healthcare professional, and they determine at that time that there's nothing they can really do. They may bandage it up, send the employee home, and then the employee comes back a day or two later, and the medical healthcare professional determines that an amputation does have to occur. If the medical amputation does happen more than 24 hours after the incident, like the scenario I just described, then again, that's not going to be a reportable amputation because the amputation did not occur within 24 hours of the incident that resulted in the injury.
Another scenario we see like that is where during that initial visit, the medical professionals determine that a medical amputation is necessary, but they need for swelling around the finger or something like that to go down before they can perform the medical amputation. And then if the procedure doesn't occur until more than 24 hours after, it would not be reportable. So it's one of these things where you've got to pay attention to the timing, contact the hospital, find out when did the admission occur, when did the actual procedure occur, get all that information before you make a report. And you really have no obligation to report, as Lindsay described earlier, until you know it's a reportable event. And you don't know that until you complete these investigations. So you have time on your side as long as you're acting in good faith and reasonable in your investigation.
And then the third common timing issue we have here is major medical treatment in the emergency room followed by inpatient admission for observation only. So this one we have talked about a little bit in the context of inpatient hospitalizations and what's required by the standard. So as we discussed, if the medical treatment occurs solely in the emergency room and the employee is only admitted for purposes of observation or monitoring after that medical treatment, then that's not going to be a reportable inpatient hospitalization. Who must report when a serious injury or illness occurs? All employers who are within OSHA's jurisdiction do have to report a serious injury or illness that meets the requirements of the standard. Even employers who fall within a partial exemption for other record-keeping purposes, for instance, based on their NAICS code, certain employers do not have to maintain injury and illness logs. Even those employers do have to report any serious injury or illness that meets the requirements of the standard. And then the other scenario that we see is multi-employer work sites. This question comes up a lot. Whose responsibility is it to report on a multi-employer work site, or where you have a host employer who has temporary workers on their site? Who is responsible for reporting? And in that scenario, the employer that supervises the worker on a day-to-day basis is the one that does have to make a report to OSHA. There's only one employer who has to report, so even where you have a scenario of a host employer and a staffing agency, only one of those employers should be making a serious injury or illness report to OSHA. Whoever supervises the worker on a day-to-day basis has the obligation, and that obligation cannot be contracted away. When you have a contract between the host employer and the staffing agency, one employer cannot contract away the responsibility to report to another. However, you can include in contracts the requirement that there be a free sharing of information about an injury or illness that occurs at the worksite to ensure that whoever does have the responsibility of recording or making a report to OSHA has the information they need to make a determination whether an incident is recordable or reportable. This slide shows the information that an employer should have at the ready when they make an injury or illness report. Most of these things are pretty basic, and the employer might know pretty easily and be ready with that information when they do contact OSHA. But it is important to have the information at the ready because OSHA will likely ask for all of this information when a report is made. And specifically as to number 7, a brief description of the work-related incident, employers do want to be strategic about the information that they provide when they make the report to OSHA. So that one particularly, we recommend that whatever representative of the employer is going to be making the report to OSHA, does consult with others at the employer to ensure that they're all on the same page for how the description of the work-related incident should be provided. There is the option to make an injury or illness report through OSHA's online portal. This was new when the rule came out and became effective back in 2015. In the past, employers were not able to report via a web portal, but this is an option now. We generally do caution against using the web portal because of the fact that by using the web portal, the employer is committing to information in writing. So when this report is sent to OSHA, they have in writing, the employer's own explanation of the details and what exactly occurred that resulted in the serious injury or illness. Because the turnaround time for making a report, 8 hours for a fatality, 24 hours for an inpatient hospitalization or amputation, is so quick, it's often the case that employers are not able to thoroughly review what happened, conduct a full investigation of what occurred before they're committing to something in writing, potentially when they use the online portal to make a report. So for that main reason, we caution against using the web portal, and would suggest instead that the employer contact OSHA by phone to make the report verbally. In addition, when there's an online system like this, there are electronic security risks that come along with it. So information that is transported over the web portal, could be at risk from a security threat. And then, the potential that this information could be made publicly available at some point by OSHA, and they have it in writing, it would reference that writing for that purpose. So what happens after the employer makes a report to OSHA? There's a couple different things that could happen as a result of a serious injury or illness report. And back in 2016, OSHA did put out an enforcement memorandum that described the steps it could take in response to a serious injury or illness report, and created 3 categories that they would generally use to determine what the response would be. And the first here is Category 1, and injury or illness reports that fall into Category 1 will generally result in an inspection by OSHA. So the first one there, you see all fatalities. Generally, if an employer reports a fatality to OSHA, an inspection will result. We have seen, a few instances where the employer maybe reports a heart attack that clearly has nothing to do with the work environment, and OSHA in that case may decide that an inspection is not required in response to that fatality report. But generally, when an employer reports a fatality, it should expect that OSHA will conduct an inspection as a result. You see here employers with a known history of injuries and repeat offenders. So if an employer has made multiple reports of serious injuries at their work site, OSHA kind of is tracking the reports that have been made by that employer. It may decide that this particular injury report would trigger an inspection of the work site. Any report from an SVEP employer, so any employer that is in the Severe Violator Enforcement Program who makes a report of a serious injury or illness, it is generally likely that OSHA will decide to inspect as a result of the injury report. So in Category 2, OSHA has a little bit more discretion about whether they will decide to conduct an inspection as a result of an injury and illness report, or whether they might issue an RRI to the employer, which is the Rapid Response Investigation Form. So in Category 2, there is a series of questions that OSHA should consider in assessing the injury or illness report and determining what they should do in response. So you'll see the first one here, was the employee exposed to a very serious hazard? OSHA might consider, what actually led to the injury or illness. Was it, an explosion occurred at the work site and resulted in an employee's serious injury or illness? If that's the case, and it's a very serious hazard, OSHA might determine that an inspection is warranted in response to that injury report. Are employees still exposed to the underlying hazard? So has the hazard been addressed? Is the employer able to address the hazard? If employees are likely to still be exposed to the underlying hazard, OSHA would likely, be more apt to inspect the work site to ensure that the hazard is being addressed. Did the employer have a work rule to address the condition, and were they followed? OSHA might obtain this information when the report is made through the brief description of what occurred, and that can weigh either in favor or against an inspection depending on the circumstances. And this slide just shows the other questions that OSHA will consider in determining whether to inspect or to issue an RRI. Does the employer have prior OSHA inspection history? If it's an employer who has had a number of inspections at the work site where this serious injury occurred, OSHA's probably more likely to decide that an inspection is warranted here and go out to the work site and inspect, as opposed to following up through the rapid response investigation. And then finally, Category 3 are those serious injury and illness reports that will result in OSHA sending to the employer what's called the Rapid Response Investigation. And the Rapid Response Investigation is a form that's sent to the employer that asks for more detail about the injury or illness that occurred, including, what the employer has done in response, what the employer has determined to be the causes of the incident that resulted in the serious injury or illness, and OSHA will request that the employer fill out this form and return it to OSHA so that it has information, more information on the serious injury or illness that it can assess. So in addition to federal OSHA's standard for what types of injuries and illnesses have to be reported to OSHA and the time frames for when those serious injuries or illnesses have to be reported, several states also have their own requirements that are slightly different than federal OSHA. So it's really important that employers in these states are aware of what those specific requirements are. And this slide shows 3 examples of states that have either very different or just slightly different requirements for what types of injuries and illnesses have to be reported and then when these injuries or illnesses have to be reported. Looking at California, California requires that any fatality or serious injury or illness be reported to OSHA immediately. And under the California law, immediately means as soon as practically possible, but no more than 8 hours from when the incident occurred. In Utah, employers have to report any fatality, disabling, significant, or serious injury or illness. So again, a broader spectrum of the types of injuries and illnesses that have to be reported to Utah OSHA. And again, a faster turnaround time. These injury and illness reports have to be made within 8 hours of the occurrence. And then down at the bottom, you have Washington. In Washington, it's any fatality or inpatient hospitalization of an employee has to be reported within 8 hours of the incident to Washington OSHA. And then any non-hospitalized amputation or loss of an eye within 24 hours of the incident. So Washington is pretty similar to federal OSHA in the types of injuries and illnesses that have to be reported. But again, those timelines are slightly different. So it's really important that an employer in Washington know that it is a faster turnaround time potentially for the inpatient hospitalization. And for any of these states where there is a difference from the federal reporting standard, the employer needs to abide by the state-specific requirement in most cases. Here, there's some data of the reports that have been made over the past 4 years since the rule has been effective. You'll notice that for all 3 of the main categories here, hospitalizations, amputations, and then total amount of serious injury and illness reports made, they've all been generally consistently rising over the last 4 years. And interestingly, you can see from this slide how many of those serious injury and illness reports, specifically how many hospitalizations and amputations, generally result in inspections once the report is made. So for hospitalizations, you're seeing around 27% in 2018, 27% of hospitalizations reported to OSHA, to federal OSHA, resulted in an inspection of the employer. And then for amputations, you see that almost half of the amputation reports made to OSHA in 2018 resulted in inspections. So again, you might have observed this theme throughout the discussion of serious injury reporting, that amputations are a real focus of OSHA. They see amputations as an indicator of an issue at the employer site, and so amputations are often resulting in inspections. Almost half of the time that reports are made, OSHA is going to decide to inspect. these are some of the common reporting mistakes that we have seen, through our experiences, again, over the last 4 years of, this rule being in place. The first one, over-reporting of hospitalizations. Again, it's the importance of understanding the nuances of an inpatient hospitalization. So there are those limitations. There has to be formal admission to the inpatient unit of a hospital or clinic, and it has to be that that treatment or care occurs once that inpatient hospitalization happens. So once the employee is actually formally admitted to an inpatient unit, there has to still be treatment or care of the employee. So both of those factors have to be in place for the hospitalization to be reportable. And we're seeing that employers, may not have the information right away when the report is made to know whether both of those requirements are met, but are making the reports anyway. So hospitalizations tend to be over-reported. Making a courtesy report. So employers sometimes want to, contact OSHA. They feel like they have some information about the outcome of the injury or illness, and so based on the information that they have thus far, they should just make a courtesy report to OSHA, even though they might not have all of the details yet, whether it's work-related, whether the requirements of the standard are met, to actually determine whether it's required to make the report. Reporting a non-employee injury. So again, it's the employer that supervises the worker on a day-to-day basis that has a responsibility for reporting. So it's important to understand which employer does fill that role, and then based on who fills that role, that is the employer that should be reporting the incident to OSHA. Only blaming the employee in the RRI response. So going back to the rapid response investigation, like I said, OSHA in that form will ask the employer to identify the causes of an incident that results in a serious injury or illness. And based on information and guidance from OSHA, it's clear that OSHA really frowns on an employer just identifying employee misconduct as the basis or the reason for the incident occurring, and they tend to scrutinize those types of reports more. So that is, something that we counsel against, just solely focusing on employee misconduct as the cause of an incident that led to a serious injury or illness. And then finally here, following federal OSHA's reporting in all states, as I talked about a couple slides ago, there are some state-specific requirements for serious injury and illness reporting. So employers who have employees in those states, you want to make sure that you're abiding by the state-specific requirement for serious injury and illness reporting. And then finally here, best practices. So these are some of the things that we've identified as important steps for employers to take in assessing whether an injury or illness has to be reported to OSHA, and then in responding to any follow-up from OSHA. So the first here, research circumstances of a hospitalization. As I just said in the prior slide, there are those important limitations based on the definition of a hospitalization that's provided in the standard. So it's important that employers really assess whether the requirements for an inpatient hospitalization under the standard have been met, and then also, considering whether the inpatient hospitalization is actually work-related. The second one, call the OSHA office to report instead of using the web portal. Again, we generally suggest that a call be made to OSHA and a verbal report be made to OSHA as opposed to committing to something in writing through the web portal. Third, for an RRI response, use OSHA's non-mandatory investigation form. When OSHA does decide to respond to a serious injury or illness report with the rapid response investigation, that form is sent to the employer, and the form can be used or the employer can provide their responses in a different form. We generally suggest using the non-mandatory investigation form that OSHA provides because it kind of just makes it easier. The form gets sent in, OSHA can look at the form, they know where all the relevant information is on that form. They can kind of quickly review it and sort of just check the box that it was completed and that the information was provided. Fourth, in the RRI response, do not list employee misconduct as the first or sole cause of injury. So again, as I said, OSHA does tend to scrutinize reports that just identify employee misconduct as the cause of the incident that led to a serious injury or illness. So employers should provide additional causes that explain what could have occurred and what could have led to that serious injury or illness to avoid that additional scrutiny. And then finally, in the RRI response, include at least one corrective action. So again, in that rapid response investigation form, there will be a space where OSHA asks that any corrective actions be provided. So we do suggest that in that space, the employer does include at least one corrective action, at least one thing that it's done to respond to the circumstances or incident or causes that resulted in the serious injury or illness, so that OSHA can see that some step was taken here to address the situation. So that is the end of our presentation. We really appreciate you all joining us for this webinar. This slide shows the upcoming webinars that we have, and we hope everyone can join us for those as well. And then finally here is our contact information. As you can probably tell from this presentation, we love this topic, we're very interested in this topic, and we're happy to answer any questions by phone or by email.
Thanks, everybody. Thanks for joining us, and we hope you can join us for the rest of the programs this year. And we're always here to help if you need it on the OSHA or the labor and employment law front. Thanks so much.